Good morning. My name is Maurice Crespi. I'm the managing partner of Schindler's Attorneys. Welcome to COBRA. COBRA is South Africa's largest pro bono initiative. The idea is that we assist businesses in distress wherever possible, outside of business rescue and in business rescue if it strictly becomes necessary. And I say that because COBRA, whilst we discuss business rescue, it's not about business rescue. The idea with COBRA is to keep you out of business rescue. Business rescue is really a last resort. Business rescue is there if a creditor applies pressure on a business unreasonably in these circumstances because everybody's in trouble. What one then does is one can put a company into business rescue, have the moratorium in place so the creditor cannot sue you, and then deal with the creditor on a level playing field. So it's only in those circumstances. There are certain commercial circumstances which we'll be discussing where business rescue is a good idea. That relates to post-commencement finance and loans to the business. So we will be dealing with that later, and that's a very important take-home that we'll be discussing. So there are instances where business rescue is appropriate, but the idea behind COBRA is to avoid business rescue. So welcome to all the attendees and welcome to my panelists. We have Ian Fleming today. Ian Fleming is the CEO of Engaged Business Turnaround, a founding partner in COBRA. We have Emma Marseille of the IQ Business Group. The IQ Business Group is the third founding partner of COBRA. Then we have Paul Michael Keichel. He's my partner at Schindler's Attorneys. Peter Gordon of Engaged Business Turnaround. Gary Barachowitz of Schindler's Attorneys, and Tisha, who is from the IQ Business Group. The format today will be a general Q&A, and it's really, really important on the basis of it being a Q&A that you guys ask questions. If you think about it, we could pre-record today and play it over and over. What would the point be if we of this webinar if we didn't get questions? So please ask questions that are industry specific or specific to your business. We'll gladly ask them. If you feel that they're too specific, let's set up a Zoom session with COBRA and the team. Bear in mind that COBRA is not only turnaround professionals. So we don't only have turnaround professionals, they're also professionals in other disciplines who we can pull into Zoom meetings and they can provide advice to you on a pro bono basis. Okay, I'm going to start by asking Peter Gordon to take us through a general overview of business rescue. That's the legislative framework and what happens with a business rescue, mindful that COBRA is there to avoid a business rescue. Peter?
Morning, Maurice. Morning, all the panelists and the participants. Welcome on this cool Monday morning. Business rescue, it's in Chapter 6 of the Companies Act. Essentially, as Maurice said in his opening address, it is there, it provides a moratorium against any legal action against the company once it's gone into business rescue. So that's not only legal action vis-a-vis claiming back of debt, but any legal action with a few exclusions, and principally that's any criminal action. If there's any criminal action that's been carried out by the company, that's not covered by Chapter 6. So what is the impact of that? Well, the directors, there are two ways to go into business rescue. Either the directors take a resolution, very simple process. They discuss it, they decide that the company is financially distressed. What does that mean? Financially distressed is defined as the company is unable to pay its debts or is likely to be unable to pay its debts within the next 6 months, or within that period, the liabilities fairly valued of the company are likely to exceed the assets fairly valued. If that is in existence, and Maurice has often made the comment that that's probably virtually every SMME, if not some of the larger companies, think of SAA, where that is the case, then the company is obligated to have a discussion at a board meeting. The directors have to agree 51% or 50% plus one to go into rescue, and the directors file that resolution together with, importantly, an affidavit. And in that affidavit, the directors, the most important thing in that is they've got to say, notwithstanding the current malaise, the directors firmly believe that given a breathing space, the company will be able to trade profitably in the future. And that's an important point, one that the business rescue practitioner, once appointed, has to declare to the creditors every time he communicates with them. That resolution and the affidavit is then filed together with a form at Sub-C, and the company on the filing, i.e. the point at which an email is sent to Sub-C, the company's in rescue. A lot of people have thought that it has to be once Sub-C has acknowledged and stamped the form, but it's on the filing of rescue, defined as the sending of the email. As at that date, all creditors are frozen. That's loans, that's the bank overdrafts, bank loans, trade creditors, anybody that the company owes money to cannot be paid unless, other than under the terms of the business rescue plan. A business rescue practitioner then has to be appointed. Importantly, the practitioner is in supervisory control of the board of directors. It is an important point because if it's a family-run business or a owner-managed business, then the practitioner walks in and takes over control of the business. A cautionary point there is make sure your business rescue practitioner is a collaborative type of person. Certainly Ian and I, when we do a number of joint rescues together, we collaborate with rather than against the board on the simple basis that surely the directors of the company, first of all, have the corporate knowledge between their ears, which is very useful to rescuing the business. And secondly, they know far more about the customers, the suppliers, the land, the market, competitors, etc., than we do. So we'd far rather work with the directors rather than against the directors. Maurice then made an important point at the beginning, and I'm going to cover it now. Post-commencement finance. It's critical for a company to get financing in, bearing in mind the first injection of post-commencement finance into the company is the fact that your creditors have been frozen. So you don't have to pay the people that you would have paid in the next 30 or 60 days. So that cash is immediately available to the company under the control of the business rescue practitioner to pay the most essential things to make sure that the company continues to trade. In addition to that, the practitioner will normally seek post-commencement finance. Obviously, the first port of call is always the shareholders of the business. There are providers of post-commencement finance in the country, distressed debt. There are not many of them, tends to be very expensive, but there are such purveyors of capital. Now, the important thing with PCF is, and indeed any funding that goes into the company, bearing in mind this includes your staff, because each day your staff work for you, you're incurring a liability. You owe them for that day's work, together with any built-up leave pay, bonuses, etc. So the staff are broadly always creditors of the company. So they, together with anybody else providing funding to the company, is immediately preferred. And what does preferred mean? The practitioner has to make sure that those creditors get paid before the creditors that were owed money as at the date of rescue. So these are, if you like, a reassurance that can be given to anybody providing post-rescue funding that they will be paid, obviously assuming that the rescue continues. If the rescue fails and lands up in liquidation, then this will partly fall away. And I say partly because the practitioner is allowed to issue security to a creditor. He has full access to the assets of the company. So any unencumbered asset, he can utilize that to provide security to the provider of the post-commencement funding. And that creditor then becomes super preferent. And if the company goes into liquidation, that security still stands and the creditor has to be paid out of the proceeds of that security. And if it's a general blanket security over of the assets of the company, subject to those that are unencumbered or not previously encumbered rather, then the practitioner has to pay, or the liquidator would have to pay those secured creditors first. So it's a very important point. Please do not put money into the company prior rescue because you want to pay the staff. It's a very common problem at the moment. People are using personal funds, shareholders are using personal funds, sometimes the directors as well, to put money into a company pre-rescue, and then shortly thereafter enter rescue, and their debt is caught up, their loans are caught up in the rescue, and as I said earlier, can only be paid out in terms of the business rescue plan. Generally, the impact of rescue is on all the people that we call affected persons. That's the shareholders, the creditors, the government, if Sars are owed money, anybody that's owed money, and the staff and the unions, if the staff are represented by a union, are classed as affected people. Staff, the rules and conditions applying to staff, it's one exclusion in the Act. The employment contracts of those people is not affected by rescue. So any staff reduction that the company would wish to go through in rescue in terms of Section 189 of the Labour Relations Act still applies. You still have to go through the process. One can fast track it to a degree, because obviously the consultation as to why the company is in difficulty is not really necessary. It's in rescue, so it's pretty obvious. Customers, the important thing with customers, and indeed the important thing with the entire process, is communication. So we will always make an effort to communicate with customers, certainly those essential customers, essential regarding supply to the company. And generally, customers will demand to go onto a COD basis. However, with the access to security the practitioner has, it is possible to secure a customer and thereby give him the reassurance that he will be paid, and thereby continue with credit facilities. Sars, people get very anxious about Sars. They are not there to put a company into liquidation. Important point. We do negotiate with Sars, and generally they are cooperative. If there's been some understatement of tax in the past requiring the disclosures to Sars, which we are required to do, then we will make that disclosure and negotiate with them on the payment and possible relief on penalties, etc. I'm not going to go into the plan. The plan has to be published.
I think we're basically covering everything. Let's get to the plan when we get to Ian. I'd like to ask Ian, before we get to the plan, before we get to further detail on business rescue, can you give us an overview of the alternative to business rescue, the statutory alternative to business rescue, which involves a compromise for creditors? So just for the audience, business rescue is a statutory option to stop creditors from being able to institute proceedings for the recovery of their debt. But there is another statutory option available, which I'd ask Ian to take us through. Ian?
Thank you, Maurice, and welcome to...
He was on Wilhelm's level, and now he's reporting to Wilhelm's Chief of Staff.
Simone? Thank you. Okay, thank you, Maurice, and welcome to everybody. Okay, so there are various alternatives to business rescue, in fact, and it's up to us, the onus is on us as turnaround practitioners to be weighing up all these options at all times, from the moment that we start engaging with the company. Sometimes it's as simple as business as usual with some minor intervention. That's fairly seldom. Sometimes we've got the option of, we look at doing an informal turnaround, keeping it out of business rescue, and we call it an informal turnaround because it takes place outside of the legal framework of business rescue. An informal turnaround is normally possible where you've got one major creditor to which the company is in default, like a bank. And because we've got a good relationship with the banks and a relationship of trust, we can negotiate with the bank without the bank wanting to close the company down or take legal action. The other option is Section 155 compromise, and this is what Maurice was alluding to. The Section 155 compromise is basically a plan that a practitioner puts together that requires the approval of each class of creditors. So the class of creditors is as defined in the liquidation scenario. You've got secured creditors, you've got preferred creditors, and you've got concurrent creditors. So typically the practitioner would put together a plan, and then he would present it. He would have a meeting and present it to the creditors, and each class of creditors would be compromised to an extent. In other words, they would have the amount owing to them reduced by an extent as a result of the plan. The vote that is required by each class of creditors is 75% of the creditors who vote, be it in person or by proxy, by value. So once each class of creditors have approved the Section 155 plan, or if it's just affecting one class of creditors, then only that class of creditors is required to vote in favour of it. Then the plan is taken to court, and the business rescue practitioner, or let's call it the turnaround practitioner in this instance, has the plan made an order of court, and effectively, immediately after he's had made an order of court, then the new balances, the creditors have taken a haircut, the company is in a solvent position and can trade forward. It is possible for the turnaround practitioner then to be involved in the trading of the company, in the turnaround of the company going forward if necessary. So that in a nutshell is Section 155 compromise. The advantages of Section 155 compromise over a business rescue is that it often can take place in a shorter time frame, it can happen a lot quicker, and it can be a lot cheaper. The disadvantages of a Section 155 compromise is that it doesn't, from the outset, it doesn't provide the company with a steel blanket that Peter talked about, the protection, the legal protection right from the outset. So while you are negotiating with creditors, it's still possible for a creditor to launch a liquidation application or to take legal action against the company. So that in a nutshell is Section 155 compromise. Obviously, the option of business rescue exists as well, and in the worst case scenario, liquidation, the option of liquidation might be the best alternative going forward. Very seldom that is the case. There's no incentive whatsoever for us to liquidate the company from the outset. We are not. There's no incentive for it whatsoever. The liquidation really is the last option. But there are instances where we need to consider it. And at any stage in the turnaround process, we need to be weighing up our options. What is the best way forward? Is it an informal turnaround? Does the company need to go into business rescue? And while it's in business rescue, we need to be asking ourselves at all times, is there a reasonable prospect of this company being saved? And if the answer is no, then we are required by law to put it into liquidation. Thanks, Maurice.
Excellent, thank you. I just want to move on to one of the take-homes that we always ask the audience to make a note of, and that's in relation to contracts such as lease agreements. Now, it was touched on by Peter, but this is going into more detail. We have the moratorium, but what we do not have is a suspension of contracts. So the contractual obligations in a lease agreement, by way of example, it's up to the business rescue practitioner to suspend those obligations, and it's only if those obligations are suspended that if the obligations are not suspended, rather, the landlord can then serve a breach notice and cancel the lease, and then the business falls to be evicted. So very, very important. If you're going to be finding a business rescue practitioner out of COBRA, make sure that the business rescue practitioner is aware of the provision, and make sure that he's armed with the details of all the counterparties to the various contracts. As Peter also mentioned, this doesn't apply to employees. When it comes to employees, it's important that one be mindful that nothing changes. The Labour Relations Act, Section 189, remains in place. It is the duty to consult, even when it comes to a variation in employment terms, such as a haircut and salary. You have to negotiate with the employees. Something that COBRA offers is that negotiation by the attorneys to assist in dealing with the employees and ensuring that there's compliance with the Labour Relations Act when it comes to a variation. What's interesting is that a lot of people, when it comes to labour, have seen and they believe that one can willy-nilly say to the employees, as from next month, you're only going to be paid 75% of your salary. You cannot do that. You need to consult with your employees in terms of Section 189 that deals with retrenchments. And though you don't intend to retrench, you still have to follow Section 189 because you have to provide the option of retrenchment to the employee as an alternative to agreeing to a 25% cut in salary. So employees, you treat the same. COBRA can assist you. We actually have weekly team meetings with businesses to advise on how to approach the employees with variations in their employment terms. And importantly, we'll get into it later, the strategy ought to be not to do a blanket haircut of, let's say, 25%, but rather look at having the employees agree to a variable salary which is pegged to cash flows, the business's cash flows. But I'll have Ian take us through that in more detail. I'm going to deal with another aspect of post-commencement finance. We've dealt with it in relation to lending money to the business. Peter's gone into that. He said that if you're going to be lending the money to the business, let's say to pay staff salaries, what's important is that one then, in the absence of a creditor applying pressure on the business, it may still be advisable to put the business into business rescue so as to ensure that you get a preference claim in relation to that loan. So you put the business into business rescue, then you lend the money. If you have security, you secure it, and then you have preference down the line on a liquidation if, for whatever reason, a liquidation ensues. So when it comes to post-commencement finance, there's another scenario that I'm going to ask you to deal with, Peter, and that's in relation to surityships. So the same principle applies, but just talk to us around surityships, because a lot of business owners have said, well, it's all well and good to put the business into business rescue because one has the benefit of the moratorium, but I sign surety. How ought one to approach that situation? Peter?
Maurice, it's a critical question. It's one that we ask in the first meeting that we have with any company that's gone into rescue, certainly in the small and medium sector. Because if an individual, normally a shareholder, but if anybody has issued a suretyship to a lender, it doesn't only have to be the bank, but it is classically the banks, then that suretyship still stands. In the early days of rescue, there was the situation where a lot of suretyships did not include business rescue as being a act of default, and therefore they couldn't claim under their suretyship until they'd had confirmation of how much they were going to get paid out through the business rescue process. And therefore the principle that was covered by the surety was uncertain until the business rescue process had been completed. The banks have got wise to that, as have most people who have taken suretyships. And where the situation nowadays is that the individual is liable alongside the bank. It's almost like a joint and several. The lender can go after either the company or the individual, and on the basis that they can't go after the company because of the moratorium, they can still go after the individual. How do we deal with that? Well, the most important thing here, and certainly if it's a director shareholder that's covered by the security, then it's important to give them reassurance that they're going to be able to thereby devote the majority of their attention to the company, which is obviously important to us as practitioners. So what we will normally do is negotiate with the bank. Ian and I are very close to the units within the bank. There are bespoke units in all the banks that deal with business rescue, and we will negotiate with them on the security. If all else fails, we'll try to be creative. We did one recently where the shareholder had a huge loan into the company, and the shareholder ceded his portion, his dividend, out of the business rescue to the security holder, so that the security holder got paid 100%, whereas other creditors only got 30 cents in the rand. So one's got to be creative with this, but it is a very important point, and obviously any director shareholder that's concerned about this is right to do so. Maurice?
Yeah, thanks, Peter. I mentioned labor costs and how to handle variable expenses. One expense being employee salaries. Ian, talk to us now as a business rescue practitioner. How does it work? So you're the man on the ground. You've been employed. You've been brought in. What's your approach?
Yes, Maurice. Employees are as an affected person in every business rescue. almost every business rescue are obviously very important, and have to be dealt with very sensitively as well, for obvious reasons. We have 10 days after the business rescue commences, 10 days after the business rescue practitioner is appointed, we're required to hold what we call a Section 148 meeting, where we meet with the employees or the employees' representatives, or the trade union, as the case may be, and we let them know whether we believe there's a reasonable prospect of returning the company to a solvent going concern. This is obviously very important for them because they want to know if they are going to retain their jobs. So it's quite normal in that meeting for us to start talking about whether we do envisage a retrenchment as part of the business rescue plan. And up till now, it has been quite normal to start retrenchment processes if necessary during the time that straight after the time that the company goes into business rescue, and then to crystallize the retrenchment plan in the business rescue plan. It's very interesting to note the SAA judgment that was passed about a week and a half ago, where the judge found that, or the judge ruled in the Labour Court, ruled that business rescue, the retrenchment processes should not commence until the business rescue plan has been published. And this is a very interesting judgment, and it certainly creates an anomaly, because this basically means that the retrenchment process can commence any time prior to business rescue starting, and it can commence any time after the business rescue plan has been published and approved. But the gap, the time in between the company going into business rescue and the plan being approved, during that time retrenchments can't commence. So the judgment is being challenged, and it's certainly an interesting judgment and food for thought. It will most likely affect business rescues going forward, and it certainly will press business rescue practitioners to get a plan published sooner rather than later, as the case should be. There's a lot of urgency in business rescue for good reason, because everything is urgent. You've got a company to save. So the 25 business days from the time that the practitioner gets appointed until he has to publish a plan are very important, and need to be adhered to as much as possible by the business rescue practitioners. So yes, we're dealing with employees from a practical perspective. Maurice hinted at, or we briefly touched on the variable cost business model, and what we've been saying right from the outset, in light of this crisis, is that almost every business is going to have to move to what we call a variable cost model as much as they possibly can. And what is meant by that is linking the cost base of the company, or the expenses of the company, to the turnover of the company is going to be so critical in order for companies to survive. That can be done with landlords, linking your rental to the landlord's turnover. A lot of you would have seen, probably about 4 weeks ago now, the Spur Group published an article, made a statement saying that should they be able to start trading again, the only way that they're going to be able to survive is by paying a minimal turnover-based rental. So we have been negotiating turnover-based rentals with landlords as much as we possibly can, and salaries, and which are traditionally known as a fixed cost, can also be changed into a variable cost under these circumstances. What we've been doing is, as part of the Section 189 process, been offering employees the option of going on to a reduced salary, sometimes a vastly reduced salary. And then as the company starts trading again, and as the turnover starts picking up, we can incrementally increase the employee salaries. Another way of doing it, and which is a very kind of technical way of doing it, and that requires a lot of transparency for the employees, is by saying to them, we will be going on to a turnover-based rental from the time that we can start, turnover-based salary from the time that we start trading again, and every month we will pay you, let's say, 30% of whatever our turnover is, until such time as your salaries are back up to where they were before, and then you will go on to your original salaries. There's very many ways of changing it. As Maurice said, Peter said, we need to be very creative, because every business is different. Every business has different nuances. Every business has different employee structures, and these things need to be thought through very carefully. But that certainly is the general rule is that we have to move to variable cost structures.
How have landlords and employees been just over the last 50 odd days?
Well, very accommodating, Maurice, at this stage. Very accommodating indeed. Employees have certainly been, employees are what they really want is at the end of the day to still have a job. They understand that if there's no money coming into the company, they simply can't get paid their normal salaries. So employees have certainly been very accommodating, and as have landlords. It's just a case, and landlords also obviously understand that if if there's no income, then they can't be expected to get their rent. So yes, yeah.
So whilst I've got you on, you're now dealing with employees. Let's talk about directors. So what's the role of directors in a business rescue? And I think also touch on the relationship between the business rescue practitioner and the directors of a company.
Certainly. So in terms of the Companies Act, once a business rescue practitioner is appointed, then the directors are basically answerable. They need to report to the business rescue practitioner, and they need to cooperate with him, and any instruction that the business rescue practitioner gives, provided it's a reasonable instruction, the directors are duty bound to obey that instruction. And as Peter mentioned earlier, that the directors, as business rescue practitioners, reasonable business rescue practitioners will always aim to work with the board because of the intricate knowledge that the board has of the company and the experience that they've got with the company. The business rescue practitioner will never, know more than the directors about the company. It is, as I said, it is the director's responsibility to listen to what the business rescue practitioner says and to answer all reasonable requests. Peter and I have both been involved in business rescues where a hostile relationship soon sort of develops between the business rescue practitioner and the directors, and the only reason for that really is when the directors have really where there cannot be a relationship of trust because they are hiding things from the business, from us as the BRPs, and various reasons those business rescues normally change into a managed wind down of the company. But as far as possible, we work with the directors, and we do get it right in most instances. The aim of business rescue was never for the relationship between the business rescue practitioner and the directors to be hostile. In those instances, it's often better to put the company into liquidation, especially if there's been fraud, avoidable dispositions, and that sort of thing, which are sometimes better dealt with by a liquidator. Maurice?
Thanks for that. Peter, the business rescue practitioner as a person, qualifications and the potential to remove him if the directors are disgruntled or they believe that they've caught him out in relation to certain nefarious activities. Peter?
Maurice, yes, a very important thing to make sure you appoint the right practitioner. A practitioner has to be a member in good standing of certain bodies, the Law Society, the South African Institute of Accountants, the Turnaround Management Association, and SAIPRA, the association affecting insolvency practitioners. So you have to be in good standing. The SIPC then issues you a license. You come with 3 levels. You are the junior, experienced, or senior. The issue there is that the practitioner, depending on their he or her seniority, cannot take on larger companies. So Edgar's SAA, for example, calls for a senior practitioner, whereas your local corner shop would probably be a junior practitioner. The calculation's based on the public interest score, the same score that's used on whether a company is required to have an audit or not. And once you've got the public interest score, you can establish what level of practitioner you need to appoint. If the once appointed, and it's an appointment by the board of directors, importantly, not the shareholders, so the directors appoint the practitioner. The interesting thing to watch out there is that you often find in the director's resolution, either to go into rescue or the appointment, that the non-executive directors have the sway, because in terms of the Companies Act, if you're listed on the exchange, a company is required to have more independent directors than executives. You've also got to have at least 3 to meet the requirements of your audit and compliance committee. In that situation, you might well find that the non-executive directors are not interested in incurring further potential liability as director, and therefore are pressurizing to go into rescue, whereas the executive might be believing that they can trade out of the current situation without going into rescue. So we often get a dispute there at the board level. Once appointed by the board, a director cannot stand forward, and that's 50% plus one of the directors, cannot stand up and said, I didn't vote, I'm going to take action against the practitioner. That's not allowed. However, importantly, if the practitioner has either not got the qualifications he said he had, is incompetent, I think Ian touched on it. I mean, thankfully, with the only positive out of this SAA judgment is that it will put pressure on practitioners to get rescues done a lot quicker. We personally believe that a lot of them drag on for far longer than they should. But dragging on, bearing in mind, is not a cause for having the practitioner removed unless there's some nefarious action. So the practitioner is bound by a level of, he can't do anything illegal. If he does anything illegal, he can be removed. And if he doesn't act in their best interest, remember the practitioner carries full fiduciary duties vis-a-vis the company. So if he's not acting in the best interest, not of the company, but of the affected people, the creditors, then somebody could go to court to have him removed. I mean, the other interesting point to remember here is there is a clause in the Act that in Section 129, which there is the appointment of, or rather the decision to go into rescue, if any of the dates are missed. Ian talked about having to have a 148 meeting with staff within 10 days. You've also got to have a 149 meeting with creditors. The board's got a certain number of days to appoint a practitioner. The practitioner's then driven by time limits. If any of those are missed and filings are done later than they should have been, somebody can approach the court to have the rescue set aside. The downside of that is you can't rectify it within the next 6 months. So it is a very important point that if you're appointing a practitioner, please, as the appointee, as the director, make sure you are aware of the time limits or get them from the practitioner and make sure that he adheres to them, and equally that the board adheres to the time limits. That's it, Maurice.
Yeah, and I'm going to be asking you just to take us through the business plan. Thanks so much for that, Peter. But before I do, I just want to mention to the audience that business rescue plans do not have to be complicated, and that, in fact, can be relatively simple. We had a restaurant in Camps Bay where we assisted legally, and we placed the restaurant, into business rescue because it simply didn't have the money to meet its expenses. And the main culprit was the landlord. The rental was not market related, and in fact had been was inflated. It was a silly deal when the directors had concluded it, and that deal had led to the business's predicament. So the business went into business rescue as a result of the landlord applying immense pressure, in fact, sending a letter of demand. The moment the company was in business rescue, the business rescue practitioners attended at the landlord because they were neutral, because they were impartial. It was easy to deal with the landlord, and they struck a deal. And the rental was reduced, and the restaurant carried on for the remainder of the lease. Now, that was mutually beneficial to the landlord and to the tenant. The landlord kept a tenant and agreed to a reduction in rental, which reduction was probably equivalent over the remaining term of the lease to the commission the landlord would have had to have paid for a new tenant. So it made commercial sense for the landlord to agree. And that business rescue lasted all of 2 months. So it was literally in and out. we've been involved in business rescues that have lasted a week. For commercial reasons, the business was put into business rescue and then pulled out of business rescue to ensure that the plan, which had already been precognized, be executed. And it didn't take much at all. So be mindful of that. But let's talk about the plan, Ian.
Thanks, Maurice. Yes, okay, so the business, I'll move on to examples of simple business rescues and quick business rescues once I've explained what a business rescue plan entails. So the business rescue plan really involves a plan, as per its name, it's the plan as to how the company will be rescued, and that's got to be the central, the core focus on of the plan. What's required by law is included in section 150 of the Companies Act, and it basically lists everything that needs to be in a business rescue plan, including a breakdown of the creditors by class, whether creditors are independent or not independent creditors, a breakdown of the different asset classes, and 3-year financial projections, income statement, balance sheet, and cash flow forecast showing how the plan is expected to roll out within the next few years. Very important to note that the business rescue practitioner only has 25 days in which to put together that plan, and so therefore the forecasts are really the way he believes at the time of publishing the plan, from the knowledge that he's gained from the company as to how he believes that the business rescue plan will roll out. And obviously many things can happen during those 3 years that alter the forecasts, or alter the way the plan is rolled out and how it translates into financial figures. A very important part of the business rescue plan is the comparison between the result that creditors will achieve, or the dividend that creditors will achieve under the business rescue plan, compared to a liquidation scenario. And we always say that in a liquidation scenario, it's not a very high benchmark, because everybody knows that under liquidation, assets are sold at fire sale values, and creditors normally get fairly little out of it. Therefore, the business rescue plans that we produce normally show quite a substantially higher return for creditors under a business rescue plan than under a liquidation scenario. And it has to be. There's no point in showing a 20% dividend in a liquidation scenario versus a 22-cent dividend in a business rescue scenario, because then you might as well liquidate the company. So that's a very important part of any business rescue plan is the comparison to the liquidation scenario. And then Maurice mentioned some simple outcomes and some quick outcomes in business rescue. We've had instances as well where we put a company into business rescue because a factory burned down and they were awaiting a very big insurance payout, and the creditors of the company weren't believing the directors when the directors said the insurance is paying out, et cetera, and the creditors were starting to call for liquidation, and starting to threaten liquidation. So we put the company into business rescue. 2 weeks later, the insurance company actually paid out, and all the creditors were settled 100 cents in the rand. Now, a business rescue plan can be as simple as relying on litigation, for example, where an insurance claim is involved. So, say for example, in the current circumstances, in the COVID-19 environment, the company is relying or hoping for a business interruption insurance claim to pay out, and the insurance company is not paying out for whatever the reason may be. If we then undertake litigation on behalf, if we put it into business rescue, undertake litigation on behalf of the company, then the business rescue plan is as simple as saying we are litigating in order to potentially achieve a settlement, and should that settlement be paid out, then the company will be better off than in a liquidation scenario, and most creditors will probably be paid. All we have to do in that situation is be able to state as business rescue practitioners that we believe there's a reasonable prospect of achieving a settlement. And if we are litigating in order to achieve a settlement, then obviously we believe that there is a reasonable prospect of achieving that settlement. So yeah, long and short of it, that is business rescue plan, and as it applies specifically to the current situation.
Fantastic. Thanks so much, Ian. Peter, can you tell us what happens if the business plan fails, either in the sense that it's not voted upon, maybe you can take us through the voting, or it's just a bad business plan and commercially it just does not work?
Mauritius, the first one is normally the one that triggers first, and that's the voting, well, always triggers first, it's a voting on the plan. In order to get a plan passed, the practitioner will publish the plan that Ian's described. Within 10 days of publishing the plan, he has to call what we call a Section 151 meeting. And everybody that's affected person gets, mainly the creditors in this case, and shareholders if they are creditors as well, get invited to that meeting. At that meeting, the practitioner is required to take them through the plan and then call for a vote. Important point here is it's only by value those creditors that are attending the meeting by person or by proxy that have a vote on the plan. There's a specific clause in the Act that excludes any creditor who wasn't in attendance and didn't vote from claiming that he or she didn't vote on the plan and therefore doesn't support it. Once that vote's called for, what the practitioner is required to do is tally up the votes, obviously, and of the creditors voting, 75% by value have got to have said yes. Now, once that is achieved, the plan is then adopted and becomes sacrosanct. That is the process that the practitioner is going to follow, and all he's required now to do is implement the plan. Of that 75%, there's a differentiation between a dependent and independent creditor. A dependent creditor would be anybody linked to the company, so intercompany loans, directors who have got money owed to them by the company, a shareholder who's got money owed to them, and their immediate relatives. So you have to be careful because the non-independent person's vote is diluted. So in an example, if you've got 100 Rand voting, you need to have at least 75 Rand say yes, and 50 Rand, i.e. 50% of the creditors voting have got to have voted positively. If you pass all those hurdles, or that hurdle, your plan is then adopted. If not, the plan it does not garner the right number of votes. The practitioner can suggest to the assembled audience that he will present an alternative plan. Obviously, he might have taken soundings in the meeting as to what the creditors wish to have in the plan. It's a bit of a silly thing to land up with because surely one's gone round creditors beforehand and discussed with them either jointly or individually as to what their expectations are of the plan, and to take soundings on what people's views are to make sure that you do get a positive vote in the plan, because it's an expensive process and time consuming to go through the plan after, to go through a second tranche of the plan. But the practitioner can then vote in get the vote to put forward an alternative plan. Also, importantly, in that first meeting, excuse me, the practitioner can allow a vote to be taken on any amendments to the plan. So if there's a minor or major amendment, as long as the practitioner agrees with the amendment, i.e. it makes commercial sense, he can put it to the vote, and all he needs is a 50% plus one vote on the amendment, and then the amended plan in the meeting goes forward for a vote. If that also fails, the practitioner then can ask for time to present an alternative. If he's silent, then a creditor can stand forward and put forward an alternative plan. If a creditor is silent, the plan has then failed, and the practitioner is then obligated to put the company into liquidation. If the plan is adopted and for whatever reason, markets change, it's not as was anticipated, because remember, one thing we know about a plan on day one, it's going to be wrong on day two, because it's a forward-looking document and we can't predict the future. So if the plan fails to the extent that the practitioner cannot implement it, and he cannot amend it sufficiently to implement it, then the practitioner at any one time, if he believes, an important point, that the creditors will be better off in liquidation than they would be in rescue, then he's obligated to put it into liquidation. If it's not the case, if he believes he can still do better in a business rescue rather than liquidation, then he's got various tools at his disposal. He can do a controlled wind down, and very often on day one, it's going to be a controlled wind down, so you put it in the plan as such. And what a controlled wind down means is that you're selling assets off under unpressurized circumstances, not a fire sale. So surely you're going to get more money for your assets than you would do in a fire sale situation, thereby beating a liquidation dividend. And if he can do that, then he's allowed to wind the company down in rescue and hand back almost the dormant shell to the shareholders at the end of the process. Once again, though, if that wind down fails and he can't sell the assets and he can't pay the creditors, then he's obligated to liquidate it. Maurice.
Yeah, thanks for that. My apologies to the audience. There's a technical glitch there. We had a desktop showing. So apologies for that. So I want to go into the costs of business rescue. Before I do, I just want to mention how COBRA is dealing with the costs and how the pro bono means test. Now, the means test is designed to ensure that all services offered by COBRA are done so on a pro bono basis for free if those fees come between a successful business rescue and a liquidation. And if there's going to be a liquidation, if COBRA was not able to come right, a liquidation application is a high court application which generally costs in the region of 30 to 50,000 rands. COBRA, so long as you join COBRA in the early days, so that you give COBRA a shot in turning your business around, if you do that, the cost of the liquidation will be covered. So on a pro bono basis, we heard about the business rescue plan. Now, in the business rescue plan, you're going to have accounts, and in the accounts, you're going to have the professional fees reflected there. Yeah. Now, the point that's being made by me is that those professional fees in the account will always allow for a successful business rescue. Ian?
That's correct, Maurice. And even prior to COBRA being started, that's the way we've always worked, is that our fees are geared towards affordability. That's the way Peter and I and our respective teams have always worked. And the Act, Chapter 6, does state what the mandatory fees are for business rescue practitioners, or the stated fees. It's typically 1,250 Rand per hour for a small company, ranging up to 2,000 Rand per hour for a large company, which includes VAT. These fees are rather outdated, with the Act having been drawn up in 2008, as we know. So typically, if a company can afford it, such as in the case of a larger company, we would put forward our own fees, say normally between 3,000 and 3,500 Rand per hour, and have that approved by the directors of the company and then by the creditors in a meeting specifically constituted in order to approve fees, which is allowed in terms of the Act. But that's only in cases where we can afford it. A typical modus operandi in small to medium-sized companies is to work out what is an affordable fee for that company and to charge that fee on a monthly basis for the duration of the business rescue. So what we're also allowed to do in terms of the Act is charge contingency fees, and contingency fees should always be structured on real successes or real milestones of success achieved during the business rescue plan. Those fees need to be approved in advance by the creditors in what we call a Section 143 meeting. We often hold the Section 143 meeting at the same time as the Section 151 meeting, which is used during which we approve the business rescue plan. So the contingency fees would be published as part of the business rescue plan. More often than not, we show a contingency fee that is linked to creditor payments. In other words, and that's what creditors want to see at the end of the day. When are they getting paid and what are they getting paid? So we will publish a business rescue plan that says when creditors get paid X, then we earn Y as a percentage. And creditors seem to, well, they look upon a plan like that very favorably because it's based on real outcomes and real successes that are achieved during the implementation of the business rescue plan. But the message that needs to come across very strongly from our side is that fees are the number one criteria when determining fees is what can the company afford to pay. And that ties in perfectly with what Maurice has said, that we will never let fees stand in the way of a successful business rescue. Thanks, Maurice.
Thanks for that, Ian. No, that's I think that's an important message, because I mean it begs the question: why wouldn't you allow Engaged and COBRA to turn your business around? Important to mention that the fees in a business rescue are different to in a liquidation. In a liquidation, it's a flat rate of 3%, 6%, or 10% depending on the asset class, whereas in a business rescue, the fees are on an hourly rate basis. So I'll give you an example. If there's a company in liquidation that owns, let's say, 10 listed shares, it would make more sense to put that company into business rescue as opposed to a liquidation, because it's very, very easy to wrap up. If the shares are listed, all one has to do is give an instruction to a broker to sell those shares, and you would obviously be low that the shares are worth 100 million rands to pay 3, 6, or 10%, as the case may be, on the assets. So business rescue is not necessarily only there for the rescue of the business, but also for a better return to creditors, as Peter mentioned. So if you can achieve a better return for creditors by looking at the business rescue fees versus liquidation, am I correct there, Ian, that is an important factor to take into account when it comes to the question of business rescue versus liquidation?
Yes, certainly, Maurice. It certainly is. It's not the most important criteria to consider, but it certainly is. It certainly is a factor. The fees to achieve in business rescue, especially where asset sales are concerned, are normally a lot lighter than liquidation fees.
www.cobra.org.za, that's the website. We haven't gone into detail in relation to the various relief funds. We didn't have Dean, our expert, today. He'll be on later this week. Dean Wright of Schindler's has worked together with IQ Business Group to put together South Africa's most detailed knowledge database on the COBRA website. They even have little robots, bots that assist you, and they guide you through the process, and everything's there. And if you struggle, again, COBRA is there for you. You can contact us by email, info@cobra.org.za, or the further details are on the website. So thank you very much for joining today. Please join us tomorrow. Tomorrow we're dealing with the event industry, and we're going to have some guest speakers who are going to be taking us through their particular experiences and their thinking. And what's quite exciting around tomorrow is we're also going to be dealing with Singularity University, and they are a California-based university, and they're technology orientated. And they look at exponential technologies, and they look at how those exponential technologies can assist in pivoting one's business in this environment. And it'll be interesting to hear what they have to say around virtual reality and the like when it comes to events. So they'll be here tomorrow. Please join us tomorrow. Thanks, everybody. Thanks to my panelists. Bye-bye.